Avulwandle. Singahlala phansi. Send my greetings to the Vice Chancellor as our host of the University of Fort Hare, Professor Buhlungu Zibula Hlahla Somnquma, and the entire management of the university, including students. And I want to assure you, had I not been refocused by Ongo Sunongonyane, I would have finished my PhD by now. So I want to make that commitment that I will graduate my PhD at this university. Forte, to me, is what Harvard is to those who live closer to Harvard. Can I also extend my greetings to members of the royal family, different royal families that are here, different kingdoms represented here, and extend warmest and fraternal greetings to my colleague, the member of the National Council of Provinces, who is also my leader in the province of the Congress of Traditional Leaders of South Africa, Unkosi Unongonyana Zanemvula. I've also seen one of our esteemed judges, Judge Lodlo, if I remember very well. Matondo, yeah. They are both from KZN. Judge Lodlo, we used to have him here. Judge Matondo. It simply means that Vice Chancellor, all arms of government are here. The executive is here, the legislature is here, and the judiciary is here. And of course, Professor Tifos and all other luminaries. Now I start. It is a privilege and an honor to address you today at this esteemed institution, the University of Fort Hare, cradle of African intellectual thought, and a training ground for many of our continent's most illustrious leaders. The topic before us, the constitutionalized system of traditional justice in the evolution of the principles of customary law in a modernized system of judicial review, speaks to the very soul of our nation's democratic journey, the meeting point of custom, tradition, and constitutionalism. Customary law shapes South African jurisprudence by being recognized as a legitimate and independent source of law, albeit one that must be developed in accordance with the Constitution. This constitutional framework requires that customary law principles be assessed for consistency with the Bill of Rights, leading to the invalidation of discriminatory practices such as male primogeniture, while fostering the transformation of customary law to promote social justice and equality. The judiciary plays a crucial role in applying and interpreting customary law, particularly through the concept of living customary law, which prioritizes actual community practices over codified, but often outdated official versions. The question we, as the universities, must answer in the context of decolonizing the pedagogical and didactical approaches to teaching and learning. What is the epistemological and ontological etiology embedding our jurisprudence? It's a question that you must answer. For as long as our tools and instruments of analysis and interpretation continue to derive legitimacy from colonial constructs, the output of our zealous efforts will give us an office of state law advisors, that will not understand why laws outside of circumcision must be referred to the National House of Traditional and Khoisan Leaders in terms of Section 39 of Traditional and Khoisan Leadership Act. Because their understanding of the role of traditional leaders should be about circumcision and all these other insignificant practices within our cultures and traditions. Anything of significance, they don't see it as relevant to the House of Traditional and Khoisan Leaders, thereby depriving over 17 million of South Africans to participate in the lawmaking process. South Africa's constitutional dispensation mandates that all laws, including customary law, are subject to the Constitution and its Bill of Rights. South Africa's Constitution is celebrated worldwide for its progressive vision of human rights, democracy, and equality. Yet, it is also unique in that it recognizes customary law and traditional institutions as integral parts of our legal order. Sections 212 and 211 of the Constitution acknowledges the role and status of traditional leadership subject to the Constitution. And of course, Section 39, subsection 2 and 3 directs our courts to develop customary law in line with the spirit, purport, and objects of the Bill of Rights, as well as equating customary law with English common law, as well as Roman Dutch law. These provisions make it clear that customary law is part of the law of the land, not a parallel or inferior system, but one that must evolve in alignment with constitutional values. Section 211, subsection 3 of the Constitution, obliges courts to apply customary law when it is applicable, but only subject to the Constitution and any legislation dealing with it. By requiring that customary law be consistent with the Bill of Rights, and courts are working to ensure that customary practices do not perpetuate subordination and inequality. The courts have recognized living customary law as the authentic form of customary law, giving it precedence over official customary law where there is a conflict, but still requiring it to be developed in alignment with constitutional values. Courts, academic researchers, and traditional leaders have all contributed significantly to the transformation and alignment of customary law with constitutional values. The Constitutional Court, through key judgments, has affirmed customary law as a legitimate and independent source of law, thereby integrating it into the broader South African legal system. The place of customary law in our democracy, traditional justice, is quite critical as succinctly embedded in our constitutional values. Thus, the system of traditional justice mediated by traditional leaders, elders, and councils has long been a mechanism for resolving disputes, maintaining order, and strengthening social cohesion. Their guiding principles include Ubuntu, the recognition of our interconnected humanity, restorative justice, focusing not on punitive, but on reconciliation, community participation, which means decisions reached through dialogue and consensus. These principles remain relevant today. In many communities, traditional justice systems provide accessible, affordable, and culturally resonant avenues for dispute resolution. By constitutionalizing traditional justice, our democracy has signaled that justice is not the monopoly of the state, but a shared responsibility enriched by our traditions. However, constitutionalizing also means accountability. Traditional justice must operate within the parameters of the Constitution and the Bill of Rights. This is where the system of judicial review plays a crucial role. It ensures that customary practices evolve in harmony with democratic principles, particularly equality before the law and freedom. The challenge before us is not to choose between customary law and modern constitutionalism, but to integrate them in a mutually reinforcing way. Customary law brings values of community reconciliation and continuity. Constitutional law brings safeguards of rights, equality, and accountability. Together, they form a hybrid system that is uniquely South African, rooted in our heritage, yet modern and progressive in its outlook. As government, through the Department of Cooperative Governance and Traditional Affairs, working together with the Department of Justice and Constitutional Development, we continue to strengthen the capacity of traditional courts following the promulgation of Traditional Courts Act number 9 of 2022, which provides a uniform legislative framework for the structure and functionality of traditional courts, aligning them with constitutional values by promoting restorative justice and reconciliation. Although a specific commencement date is yet to be proclaimed, myself and Deputy Minister of Justice and Constitutional Development, Honorable Andries Nel, we are busy developing its regulations to suit the purpose. It must be emphasized, though, that traditional courts are courts of law in terms of Section 166E, read together with Item 16 of Schedule 6 of the Constitution. The Act recognizes the role of traditional leadership in the administration of justice and affirms the application of customary law within the Republic's legal system. The Act aims to ensure that the traditional justice system operates in line with the Constitution of the Republic of South Africa, including its recognition of customary law and the institution of traditional leadership. It promotes a justice system based on restorative principles and reconciliation rather than purely retributive forms of justice. The Act provides for the settlement of civil and some criminal disputes by traditional courts, which can be more accessible and appropriate for communities. We are committed to work with institutions of higher learning, like this university, to produce research, jurisprudence, and graduates who can advance this delicate balance. The future of traditional justice lies not in resisting change, but in leading transformation from within. Our traditional leaders must be partners in building a constitutional democracy that is both African in identity and universal in values. As I conclude, our courts are required to develop customary law in a manner that aligns with the Constitution and promotes social justice, particularly through the principle of Ubuntu. As we reflect today, let us remember that our Constitution did not seek to erase our traditions. Instead, it sought to constitutionalize them, to give them new life in a democracy that belongs to all of us. The evolution of customary law is proof that our past and present can work together to shape a just future. A future where custom and constitution are not rivals, but allies in the pursuit of justice, dignity, and equality. It is now the task of this generation of scholars, leaders, and practitioners to ensure that this vision becomes a reality. I thank you.
Thank you, Deputy Minister. I was worried when you were delayed in another meeting that we might not get the same energy as we are getting now, but I'm at ease now. I'm at ease. May I call upon Professor Shane to take the podium, or you are also welcome, the Prof. Over to you.
Thank Thank you very much. And a special thank you to Professor Lama Makanya, to the Dean, and to the entire Faculty of Law here at the University of Fort Hare. It's a real honor, a real privilege to be here at this very important event. I've learned a lot over the past couple of days, a lot. And what I hope to contribute to the conversation is a perspective on international customary law, international customs. So let me begin, if I may. So customary international law usually refers to the rules and principles of international law that derive from general practices accepted as law. Instead of speaking about that, what I want to speak about is a different kind of customary international law, which usually goes unacknowledged. These are general practices, cultural practices, that give authority to international law. So, that's okay. There are some images I'll need if we could get that back online. But the shift I'm making here is a shift from thinking about the role of custom in international law, rather than focusing on repeated state practices as a source of rules and principles. I want to think about repeated cultural practices as a source of authority within international law. There are many different kinds of repeated cultural practices that give authority to international law. The two that I want to think about in particular are geography and historiography. Okay? So this is really about how world history is understood and represented and how history is told. It's about, in short, the repetition of a particular version of world history with a capital W, a capital H. A particular version of world history that helps to generate and sustain the authority of international law. And I think of relevance to this gathering, how this in turn works to deny customary law in countries around the world. So I'll just begin with an example, the one on this slide here. It's the most recent judgment of the International Court of Justice. It was handed down in May this year. It's a case between Gabon and Equatorial Guinea concerning land and maritime borders as well as sovereignty over islands. The court was not asked to resolve these territorial claims, rather it was asked to determine the applicable law. So the question for the court was to determine whether certain titles, certain treaties, certain conventions invoked by the parties have the force of law. And to work that out, the court turned to international customary law, and specifically the customary international law of treaties. Okay? And this includes a rule that an intention of the parties to be legally bound is necessary for an instrument to constitute a treaty. So I put this up because it's just an example of how the court and how international lawyers more generally think about custom in international law as a source of rules. And my argument is that there is another way in which customary practices matter in this case. Specifically, the argument is that the court was engaging in its own customary practices, which gave authority to this judgment, but which go unacknowledged in the judgment itself. And these customary practices are very much in the background. In fact, they're literally in the background. So the first section of the judgment is general background. It consists of two subsections, geography and history. What kind of world history is being repeated in this text? Okay. It's an origin story, and it's an origin story that begins with Europe. It begins with European colonization, which is to say the court's historiography, according to this part of Africa, this part of Central Africa, has no relevant history before Europeans arrived. You can see here, B, history, originally colonies, right? Originally colonies. So the court's historical starting point is 1778, to be precise. It's the Treaty of El Pardo. It's an agreement between Portugal and Spain. That treaty was really an attempt to clarify an older treaty, the Treaty of Tordesillas. It's an infamous agreement between Portugal and Spain in the 15th century, which sought to divide the newly discovered world between them. So the relevant history here for the court, it really starts in Europe. It starts in the 15th century. But the main historical markers are the 19th century, including 1858, Spain's royal order establishing the colony of Spanish Guinea, 1885, treaty between German Cameroon, French Congo, and so on. The point here is that it is these historical events and these actors, Spain, Germany, France, that matter in this history. So here's a map provided in the judgment. It helps to visualize this history. So in terms of scale, the map is zoomed out just far enough to be able to see the relevant European colonies, their territorial claims in this part of Africa. So at this scale, it's these European empires that appear as the proper subjects of international law. For contrast, this is another way of visualizing this part of Central Africa. It's not included in the judgment. The scale is no longer that of the European empires. The scale is now some dozen Central African political groupings imagined along linguistic lines. So it's the Fang, the Beti, the largest groups in blue. And it gives a very different picture of the potential subjects of international law. This picture makes visible, it makes possible, it makes visible a potentially different international law, an African customary international law. But this is not relevant to the court. The history and geography of the court that the court invokes that really grounds its international law renders this other map invisible. So this is not news, I don't think, to anybody here, but what I want to draw out is an insight that has been developed by scholars in law and geography, particularly work that's been done on mapping. So these scholars have shown that maps do not just reflect or illustrate legal claims, but they really do the work of contributing to extending those legal claims over the world. It's what Sabaris Suresh, whose quote is on the slide, it's what he calls the juridical potentiality of a map. And this is a map's capacity to override existing legal arrangements and proliferate and project legal realities of its own. So an example of this is this one. It's the Theatrum Orbis Terrarum, published in Antwerp in 1570. It was the first modern atlas in Europe, created by Abraham Ortelius, a Flemish geographer, to King Philip II. So how does this map imagine world history? It's an old story. You see in the frontispiece the image on the left. Maybe you can make it out, maybe you can't. But what you have is the figure of crowned Europa sitting at the top, of course, sitting on her throne, an oversized imperial orb by her side. And Europa overlooks the figures of Asia, Africa, the courtiers, and at their feet is a prostrate America reclining, as well as a little-known figure at that time who went by many names, including Terra Australis, the great southern land. So in this imaginary, these continental figures, these 5 continental figures, are the main actors on the world stage, but there is no doubt in this imaginary who reigns supreme, nor about who is still nascent in world history. And of course, at the time of this map, 1570, this was not an illustration of how the world was. It was really a fantasy, right? It was a European fantasy, an imagined international legal order in which Europe would reign supreme. So this same imaginary is represented in this, the most famous of the pictures in the atlas. It's based on Mercator's projection of 1569, the most infamous map projection of all. The Mercator projection should be familiar. It was this attempt to create a map that reflected not myth, but so-called reality, based on scientific cartography. But the result is well known. So in the process of projecting the spherical surface of the globe onto this flat page, the equatorial region is shrunk and the northern hemisphere is enlarged, and Europe is also incidentally placed at the center. This is, of course, very much in use still, the Mercator projection. The African Union recently joined the campaign Correct the Map to abolish its use. Why? We know because, of course, the map doesn't simply reflect the world as it is, it represents the world in a particular way, which both expresses a European sense of superiority and in do so contributes to that sense. And that really is the point that I'm drawing out of this here, that maps don't just reflect the world as it is, they really represent a way of seeing the world, and in doing so contribute to that reality, to making that reality. Okay, so I have 1 minute. Okay, so very quickly, in wrapping up, I just want to turn to a different example, and this is the work of international development. To paraphrase Rajagopal, my concern here is not the rules of international development law, it's really, again, the practices of geography, the practices of history that reproduce an understanding of world history which authorized the work of international development. So, the World Bank in particular, the World Development Report I've got here from 2006, it develops an argument for why having good legal institutions leads to prosperity. And to make this argument, the bank examines what it calls the large natural experiment of colonization. And in this experiment, Europeans, this is the bank's language, created good institutions, good legal institutions in some colonies, and bad ones in others. The bank then engages in an analysis of how these different institutions were developed historically in these places, and this analysis grounds the work of the bank. It really authorizes that work. So again, what is the world history that authorizes that work? It comes out in a case study that the bank uses. And again, it's a case study of colonial origins. This is one in which Latin America has a history of extraction, authoritarianism, oligarchy, while the history of the US is of relative egalitarianism and representative institutions. And the important point here, which I'll finish with, is that the history of successful development, according to the bank in North America, is told from a particular standpoint in history. And again, it's that of the European colonists and their descendants. So, in contrast, from the standpoint of the indigenous peoples, whose experiences of colonization in North America were of genocide, intergenerational oppression, or from the standpoint of the descendants of African slaves, whose experiences were overwhelmingly of exclusion and economic impoverishment, these colonial origin legal institutions were not looking so good. So from these standpoints, the good institutions, the good legal institutions, were the indigenous ones or the African origin ones. And yet these very legal institutions, these customary legal institutions that are denied as being lawful by that institutional system that was set up in the US, are denied being called good by the bank as well. So these customary legal institutions are squarely in the bank's category of bad ones for the reason that they tend to offer radically different understandings of shared prosperity, which do not follow the bank's model of development, of growth. Finally, you can see again, what is the world history that's being used to ground this work at the World Bank. It's on full display in this final slide that I've got from the 2017 World Development Report. So according to this report, history reveals 3 types of transition. The first is a transition from customary law to modern law, right? What the bank calls customary law, what the bank calls modern law. So in this understanding of world history, again, customary legal institutions are inevitably replaced by European origin institutions. And again, is the purported inevitability, the naturalness, the universality of this world history that justifies and authorizes the international development work that the bank is doing to build these legal institutions. So I'll end here. What I wanted to draw out, though, very quickly was just to contribute conversation about how there are these certain customary practices which were used within these international institutions, unacknowledged cultural practices which repeat a version of world history which has a very long history, and that world history itself works to authorize and justify the work of, from the ICJ to the World Bank. And it's important to pay attention to these because they also work in turn to deny customary law in countries around the world. Apologies for going over time, and thank you very much. Thank you.
Thank you, Professor Shalmas. A very interesting topic, calling upon internalization of customary practices, and somehow it links, with the deputy ministers. One of the things that came into my mind is, the traditional method of resolving dispute peacefully, which has found its way in international law, mediation, that has become a sort of, accepted principle throughout the world. But the time for discussion will come, we'll get there. For now, allow me to call upon Professor Diale. A round of applause for him. Thank you.
Good morning, everyone.
I recognize all the dignitaries here and the traditional authorities, but due to limited time, I cannot be specific. You would have seen my topic on the program. Here is a disclaimer. I did not choose that topic. It chose me. But I will still say something about the topic. I've been asked to speak on modernity and traditional governance in Africa. So I'll do three things. First, I will explain the history of modernity. Then I shall link it to globalization and its poster child, European colonialism. Then I will conclude with the impact on traditional governance in Africa, with focus on South Africa. So what's modernity? I would have loved to tell you a story, but I don't have enough time to tell a story. So let me just make this very quick. Sometime in the 17th century, some say the late 17th century, something happened in Europe. There began a shift, a cultural and intellectual shift that is now known as the Enlightenment period. Europe began to focus more on science as opposed to superstition, began to focus more on reason as opposed to faith or belief, and began to focus more on individualism as opposed to communality. That is not all. There began to emerge an emphasis on industrialization. We know today the first industrial revolution, the second industrial revolution. All these are part of what we describe as modernity. Now we got nation states as opposed to the mostly acephalous societies of pre-colonial Africa. Apart from the large city states that you would find in the African continent, most communities were just informal groupings wherein organization was from the clan or the extended family. But modernity gave us nation states. Importantly, it gave us capitalism. Capitalism as opposed to welfareism, Ubuntu, as we know, in our traditional settings. And then, of course, it gave us technology. Enough said about technology. I'm not going to say anything about it. We are now in the age of AI. We are moving towards blurring the line between reality and illusion with holograms and the rest of them. But the most important aspect of modernity is what I call universalism. Now, universalism simply means imposing the same standards on everyone. Modernity made Europeans so excited that they began to export their culture. No, sorry. Impose their culture on other parts of the world. We know it today as European colonialism that championed this idea of a civilizing mission. Think of a child that just learned how to walk. The excitement of the child to explore. That's what the Europeans brought to other parts of the world, and that colonialism set the stage for the present system of traditional governance in South Africa and elsewhere. Now, colonialism thrived on this concept of indirect rule. So the Europeans used Africans to govern Africans. It's continuing today. The main impact on traditional governance is the way that traditional governance is conducted in South Africa and elsewhere also. So we know the principal legislation, example, the Traditional and Coercion Leadership Act that replaced the Traditional Leadership and Governance Framework Act. But let's not speak about this. Let's rather speak about the impact of European colonialism on behavior, on traditional governance. There is something that we often miss when we speak about colonialism. Colonialism, as I said, is the poster child of globalization. But think of it as the shock troops of globalization. So what is the purpose of globalization? It's singularity, integrating the world, both economies, culture, everything. So to integrate the world into unity, the same thing that AI, well, let me not go there, too controversial. But that uniforming mission, that civilizing mission, everything that colonialism brought ties in with this idea that we all, despite our differences, that we can be forced into, pigeonholed into one normative image. And this is the context in which I make three claims. First, that European colonialism created Africans in the image, the normative or behavioral image of Europeans. That's number one. Two, even though indigenous African customs predate, they are older than the Constitution. The Constitution is worshipped as a deity in South Africa, even though it's a foreign document that was adopted with minimal input from Africans. And finally, claim number three, that because of the homogenizing influence, this uniformizing influence of the Constitution and other laws, statutory laws that were imposed by European colonialism, eventually, indigenous African customs will disappear. And they will be replaced with what? With European culture. Unless Africans take conscious, deliberate steps to preserve the spirit of their laws by ascertaining the foundational values and in mainstreaming them into policy and other law statutory reforms. These are the three claims, and that's the future of traditional governance in South Africa. But let me explain a few things that will bring this thing home. When we speak about statutory laws in South Africa, there's something that we forget. And by statutory laws, the chief culprit is the Constitution. There is something that we forget. And that thing is that these statutory laws are actually colonially imposed laws. They are survivals and they are adaptations. That's number one. Number two, when we speak of African customary laws, we conflate two things and lump them together. We lump indigenous African laws together with the distortions of indigenous African laws and the adaptations of indigenous African laws to the changes brought by European colonialism. Whereas we should not do that. We should draw a distinction between the practices of our ancestors before the Europeans came and their reactions to the socio-economic changes that the Europeans imposed on their lives. So we must have African customary laws separate, and we must have indigenous African laws separate. If there's going to be an eventual common law in South Africa, if traditional governance is going to be legislated into uniformity, then it's going to be on the basis of African customary laws, which are hybrids of indigenous laws and colonially imposed changes. If you have looked at the guiding principles in Section 2 of the Traditional and Khoisan Leadership Act, you would have noticed that it brought in the same things that you see in all the laws regulating indigenous behavior in South Africa. And those are three constitutional principles. Three principles in the Bills of Rights. One, equality. Two, non-discrimination. And three, either human dignity or gender equality. Now in this act, they removed human dignity and substituted it with increasing gender representation in traditional governance. But apart from that, these three principles are the same that you will find in the Recognition of Customary Marriages Act, laws of succession, everything. The homogenizing principle, uniformizing principles of equality, human dignity, and non-discrimination, all of which try to do what? Pigeonhole, mold behavior of Africans to embrace modernity, to embrace these universal values. Is it good? It is good in some aspects, but it's also bad in other aspects, because you cannot lump communities with disparate cultures into nationhood and expect things to work well. Why? Because when the Europeans came to this part of the world, Africans were still doing what? In an agricultural stage. Society has evolved over the years. We did not always have the bright lights we have today. There were times when people were just based on cannibalism, eating raw food, raw meat. They had not even discovered fire. But eventually fire was discovered, societies moved, then the Industrial Revolution. Europeans had moved to the second Industrial Revolution by the time they imposed their capitalist, individual-focused industrial laws on African societies, whereas Africans were still in an agrarian stage. So what could possibly go wrong? There will always be tensions between traditional values and the imposed values. And for us to manage these tensions appropriately, we must look to the foundational values of indigenous African laws. We must look to the legal histories of previously colonized nations to make sure that our values and our customs are not wiped out and destroyed. I thank you.
Thank you, Prof, for that insightful presentation. We are now getting to the Q&A session, but from what I can take from these three presentations, starting from, lawmaking process, that certain issues that have to do with traditional issues or related in the regulation of customary practices. The suggestion is that those should be given to a specific lawmaking body, such as traditional leaders. Then there was also an emphasis on the call for internalization of customary practices. Then Professor Diale concluded with, integrating traditional customary practices of cooperative governance into modern systems. And what came into mind there, that process of, adopting the African Charter, if you look at it to a large extent, it differs with all other instruments in that the leaders, when adopting that, they tried as far as possible to include, traditional practices, but I won't go there. I will start with the questions on the right. I will take 3, then I will move to the left, then I will move and also allow the program director to pose questions. Over to you, sir. Please indicate to whom the question is directed to.
Thank you, Program Director. Usually my roar is loud enough not to use a mic, but for the interest of the delegates here, let me use the mic. My question is, or questions, is directed straight to the Minister Burns Mkamashe, Zweli Ajika. Allow me to also recognize the presence of Nkosi Nonkonyana, the chair of Contralesa in the province, Zanembulu. I also want to make known that I was nominated by Nkosi Makinana at the PEC meeting of Contralesa in the province to become the direct elect for Contralesa, representing the Eastern Cape on the NEC. And his words were that it is a progressive move to indicate to the country the seriousness of Contralesa in including the Khoi and San representatives in structures relating to traditional and Khoi and San governance. And I'm standing, usually I would sit. In my culture, I'm not expected to stand because I should not be looking down to those that I speak to. But I am standing by virtue of respect to the Deputy Minister's office and respect to him as a traditional leader also. Honorable Deputy Minister, my question is simple, and I'm not trying to ambush you because we know we come back quite some time. I was there when you pleaded to the Minister Nkosazana Dlamini Zuma for formal recognition of Kakabe, and I emphasized the colonial wars.
Sorry, in the interest of time, please
no
go
problem.
to the question. Thank you.
No problem. Formal recognition of the Khoi and San. Can we perhaps get a specific date as to when that process will be expected to be completed by your office? Is the government serious about the formalization of Khoi and San communities, or is it in the government's, or is the government content with the current chaotic state of affairs of the Khoi and San. Our country's legal processes leads as follows. You have law captured in statute. That gives a form of regulations guiding the process to be followed in order to achieve results. In 2022, we accepted the law, followed the process. We are still awaiting results, which brings in the doctrine of justice delayed is justice denied. And my question is, you spoke on restorative justice. Why is restorative justice an illusion to us and not afforded to us as the Khoi and San communities? Then the former President Robert Mugabe once said, for us in Africa, the current antiquated system perpetuates a historic injustice, one that can never ever be justified today. Deputy Minister, you spoke on Monday at the engagement we were both attending at Nelson Mandela University, when you said how one would want to be remembered. Let us remember you as that Deputy Minister who gave justice to the Khoi and San. Thank you.
Do we have any question? I think you raise questions on behalf of everyone. Professor Ntlama?
Thank you, Program Director. My question is just simple. The Constitution says that in that section 166, that the judicial structure of the Republic, it goes to any other court. Now, traditional courts are not included within that structure, but instead you have to interpret them through that other. So it means that the structure, the judicial structure, there is no way where you find traditional courts, which today we are striving towards that they transmit restorative justice. But constitutionally, we have to find ways as to what that other mean. Luckily, Deputy Minister, we have you, and also we have the Member of Parliament. The Constitution, we are very happy about it, but the courts themselves that define who we are, we have to interpret them through the other. Thank you.
Thank you, Prof. I need one more question. Judge Madonna?
Sorry, Program Director. You said you'll come to this side. I have 3 questions as well, but now we talk part of 1. I have a question to Professor Chalmers and to Professor, and I got the first name, Gatsi, if I'm correct. Professor Chalmers, so I want to know that in your view, under what circumstances may African customary law be applicable internationally? That's my question for you. And this other Professor Sitiano Gansi, I don't know. In your view, what could be more appropriate in the case of customary law between consolidation and unification of this law? Thank you.
Thank you, Judge. Panelists, you may respond.
Okay. No, thanks very much, Program Director. I think in giving answers to the first questions on the recognition of the Khoi and San, Well, in terms of our processes, there's a commission that has been established to subject all claims to positions of royalty into being interrogated. Because as you know, we have a proliferation of claims at different levels. So to authenticate the legitimacy of those claims, they have to be subjected to an audit process. We have since identified some weaknesses within the investigative body, and we have now begun a process to augment the capacity with the aim of at least come the end of the financial year, we have the first batch of Khoi and San communities and their leaders being recognized. So that's what we intend to do. Now, secondly, in relation to the integration of the Khoi and San into the structures, formal structures, it's kind of a catch-22 situation in the sense that now that, for instance, on the 29th of May, all claimants submitted, is there no risk of preempting what could be the outcome by giving that recognition when the process of audit is in progress? Why don't we then expedite the process now that there are claims, so that those who are integrated into the system, it's those who have an authentic and legitimate, or whose authentic and legitimate claim has been proven beyond reproach. Because as you know, anyone and everyone is calling him or herself, or ascribing to him or herself a position in one form or another. And we can't say what you say you are is wrong until we subject all of that into the audit process. And there are those who are actually rejected by the system, and now they're trying to create chaos. And they know that they don't fit the criteria that is there. So they start to question even the legal validity of the processes. We are aware of those kind of, but we are equal to the task. We will deal with it as and when it comes. I mean, and as you know, we are also in the process of amending the law. And for a simple reason, the amendment to the law largely was influenced by our own observations of the weaknesses within the law. We are the ones who actually identified that within the hierarchy of positions that are there, you only have senior Khoi and branch leaders, which is an equivalent of a senior traditional leader, as well as headmen and headwomen. When we know that there are Khoi leaders who are recognized by other Khoi leaders as the most senior, to a level of being referred to as Kubaha, which is an equivalent of a king. Now, in respect of the Khoi and San, we don't have that position of a king or queen. So the amendment process opens up that window of opportunity for the Khoi and San communities to really bring about those motions so that they find expression in the legislation. And of course, I take it that even other strategic bodies like Contralesa will be able to add their voices in terms of the amendment process. And in respect of Prof, well, I take it that I've also answered the justice delayed and justice, justice denied is justice delayed. Justice delayed, yeah, justice denied, yeah. You know, yeah. Now let's come to section 166E of the Constitution. Section 166E, Prof, was actually well ventilated during the certification judgment of 1996, before the final adoption of the Constitution. And fortunately, Nkosi Nongonyane is here, was one of the advocates who actually took the matter to court at the time. And I agree with you that it's implicit. And the irony is that the 1993 interim constitution, which was adopted by the last apartheid state parliament, was more manifest on the roles and positions of royalty. And sadly, in 1996 version, it was only, or rather, it focused more on being minimalistic in terms, guided, of course, by principles 13 and 17. You know, out of all the 34 principles that underpin the final constitution, you only had those two that specifically spoke to issues of royalty. And of course, our courts were also covered so implicitly, even when we had to pass the traditional courts as an act, there was a strong view from the NGOs rather to suggest that they be alternative dispute resolution mechanisms than courts of law. And we insisted, fortunately, Professor Mqege was there, we insisted that no. Read your constitution. You can't be innovative and creative about what the constitution says. If you look at Schedule 6, item 16, it is very specific about the existence of traditional courts. These are courts of law. So to the extent that there may be a sense of doubt, I can confirm that these issues were well ventilated to the extent that traditional courts are courts of law in the same way as it would apply to all other courts of law. I think from my side, those are the questions that were raised. And of course, masters and PhD students should really focus on topics of this nature, because there are no other people to develop customary law other than ourselves using the autoethnographic systems of research and data collection and all of that. Thanks.
Thank you, Deputy Minister.
Thank you very much for the question. So there is a significant body of African customary international law that has been developed. It applies, is generated through the interaction of states, African states, and generally operates within the continent. And there's a great body of scholarship on African approaches to international law, which is contributing a lot at the moment. The issue, though, and I think the challenge, is what happens when you come up against these international institutions, such as the World Bank, and there are many others, where there's a particular, and I think this goes to Professor Diala's point about the uniforming mission, what used to be the civilizing mission, this uniforming mission, where there's a particular history, a particular world history that still is repeated within these international institutions, the World Bank. There are others, such as there's a study of truth commissions around the world. I'm not so familiar with South Africa's, but with other truth commissions, where again a particular world history authorizes the work of those institutions. So only certain claims can be made, only certain truths can be recognized within those institutions according to that sort of world history. And it's very difficult to make other claims and have them recognized. So I think the issue really is that this continuing repetition of this world history, which denies other ways of understanding history and the world, other perspectives. And when that authorizes the work of the World Bank, it makes it very difficult for other claims to be made or heard.
Thank you, Prof.
All right, I've been asked to comment on what is more appropriate between consolidation and modification of customary law. The more appropriate question is this: what do you want to consolidate and what do you want to modify? In a nation of astonishing cultural pluralism like South Africa, with communities having disparate customs, different customs, what do you want to modify? What do you want to codify? We must be careful when we speak about modifying or consolidating customary law. That's why I draw a distinction between indigenous African laws and African customary laws. They are two different things. Let me give you one topical example, very recent example. The surname judgment, that men can now take the surname of their wives. And the traditional leaders were protesting. I smiled when I saw that. Then I decided to write something. So I published something in the Conversation on Friday, last Friday. And there I traced the colonial origin of surnames. Many Africans do not know that surnames, it's a colonial import. The Europeans brought it. In the past, Africans did not have surnames. What is, oh, my name is maybe Andiswa, the daughter of so-so-and-so. Or Seshaba, the son of so-so and so. That's what was there in the past. But colonialism brought this idea of surnames as a means of control, economic control, political control, etc. But now it has become customary law. So we must be careful when we say we want to consolidate, what do we want to modify, what do we want to consolidate? What is customary law? What is indigenous African law? There's confusion, we don't know, and all because of this modernity, influence of modernity.
Thank you. Thank you. No, I'll use this one. Thank you, Deputy Minister. I see this topic as we are about to conclude, it's gaining momentum. But we're still going to have tea. Therefore, we will take more discussions to the tea room so that, we don't get behind too much. As I'm about to conclude this session, I would like to make one minor announcement. If I may call upon Chief Mvuyisi Zwelibanzi to stand up so that people can see him. Chief, are you still with us? Please. I think, no, we wanted to actually surprise, the chief and sing a happy birthday to him. But in absentia, happy birthday, chief. To our panelists, thank you very much for taking your time and, providing these insightful discussions. There's no one answer with a collective approach on how we deal with the issue of evolving customary law. If we could please clap on behalf of our audience, panelists. You are also very patient and, engaging audience, you also deserve your own round of applause. Chief, happy birthday to you again. We hope that you will enjoy your day. I cannot sing, Prof, but you can assist. Day to you, happy birthday, dear Prince. Happy birthday to you. How old are you now? 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 Hooray! Thank you, Chief. We are going to have a short break, about 10 minutes, then we'll come back for our last session. Thank you so much. The discussion is over. You may move to the tea room. Thank you. final panelist is Professor E.S. Nwauche, one of our own University of Fort Hare. Prof, welcome on stage. His topic is entitled The Distinction Between Voluntary and Compulsory Traditional Levies in South Africa. Muhlala and others versus Minister of Cooperative Governance and Traditional Affairs and others. Panelists, the usual protocol has been observed and we shall stick to the time frame, which is 10 minutes, and the timekeeper will indicate as and when you should approach your concluding remarks. Nkosi, the platform is yours, sir. You are free to present there or you may take the podium. Welcome.
Well, Program Director, and all the eminent persons here, Your Royal Highness, academia and students, good afternoon. I thought I should not read from the paper. I must just talk. And in talking, I'm not so sure, Program Director, whether I'll be able, but give me a signal. Well, I think for the first and foremost, thank you very much, University, for inviting us, the Congress of Traditional Leaders of South Africa. I'm with the leadership, the Deputy Secretary of the Province, Nkosi Malahle is here, and all other Royal Highnesses are here, as well as yours, Chief Peterson, our national representative. We are really grateful. For me, I studied here at this university, law, and I graduated here. I felt I must set aside everything with a view for me to come, because I think it is for the first time that I've been invited. I only know that the university some time ago did invite Contralesa to share our confidential material as we were galvanizing the support of traditional leaders in the country as part of the broad liberation movement. Thanks that I've decided to come. I may also indicate that I would be pleased to come again. Well, as those who spoke before me today clearly stated, we are in a constitutional state with a rule of law, and fortunately for me, I've been part of the entire process. I was the leader of Cape Delegation of Traditional Leaders when there were negotiations for a new democratic South Africa. The first hurdle that we needed to jump was to be accommodated at that forum. As many of you may know, there was CODESA 1, we were not there, it collapsed. There was CODESA 2, it collapsed whilst we were still engaging the parties involved for traditional leaders to be accommodated. Of course, in a forum that many of you do not know, which had no name, a negotiating forum, we were able then to adopt principles that we mandated the Constitutional Assembly to be guided in adopting a constitution. Constitutional principle number 11 clearly provides for the role and powers of the institution of traditional leadership in South Africa. And constitutional principle number 17 also provided that there will be democratic representation, but throughout and all those, but there will be a role. It does not derogate from principle number 13 that I've quoted to you. But when the Constitution was adopted, we found the sections that were quoted by Prince Pence Namashe this morning. And we decided as Controlesa to go to the Constitutional Court to object to the certification of that Constitution, precisely on the basis of what those that discussed this issue of customary law told you. But I will restrict on various grounds, but for today, I will restrict to the topic that I've been given. Customary law, as far as we're concerned, is the law of the land. We criticize the Constitution that it is Eurocentric and it will create challenges along the way. We even, as Professor raised the question, said, in this country, South Africa, customary courts are courts of law, and they must be recognized as such. We argued that matter, and the Constitutional Court judges said, well, we're not so sure, because we're in the Republic, whether it will be possible for us to accommodate the institution of traditional leadership. Let's just wait for the laws, but they have a leeway that if there is any law that is going to militate against the institution, we'll be able to go back to the Constitutional Court. And so we were recognized as other. Precisely because of that, Parliament took more than 20 years to pilot a bill on traditional courts. You heard this morning that bill, that act now, which has been assented by the President, has not even been operationalized. There are still regulations. I can dare say that there is no budget for it, which means, therefore, the customary courts or traditional courts will not be operational in terms of the law, but I can dare tell you that it continues to operate. So as far as we're concerned, because customary law has been recognized in the Constitution in the same way as the Roman Dutch system, but many South Africans said, well, there's the Roman Dutch law is the common law of South Africa, and we hold a different view. Because we say Roman Dutch law, which is the law that we inherited from our oppressors, is there, but our own law, the indigenous law, customary law, is still the law. But fortunately, the Constitution does recognize that. On the basis of that, we continue to exist today. And so there is a legal framework for us to operate. But because mainly many of our fundis, they have not specialized in African law. Professor Arbim Mqeke, who was our professor here, and many others taught us that we need to really continue to agitate and struggle for the recognition of customary law, which we have done. For instance, in my LLB dissertation, I then actually have a topic on repugnancy clause. That's the section 11 of the Bantu Administration Act of 1927, which I intend then to publish with a view to compare it, because now customary law is subject to the Bill of Rights. And the Bill of Rights had incorporated the westernized norms and values. For instance, we have got a problem with the recent judgment that Nonkonyana may be my wife number 1, my wife number 2, no, my wife number 3 surname, which will be a complete confusion as far as we are concerned, because some of us, including kings, we don't have one wife. We have got wives. I've heard the professor saying, well, it is colonial, maybe Muelo, which is my name, which is fine, but the effect of the matter is that that judgment has actually raised what we have raised with Olomisa was there, and the late Mama Winnie Mandela, we were there, saying this application of equality horizontally will give a problem. We have no problem with, no, vertically rather, we have no problem with its application horizontally, that is between the state and all individual, we are all equal. But amongst ourselves, I cannot be equal to my younger brother, I cannot be equal to my mother. And that is why, therefore, we had that problem. And hence, therefore, the legislation that must be guided against. We have the laws, the legislation that was passed. Now we do have the Traditional and Khoisan Act of 2019, which has been crushed to be unconstitutional. But we have been given a leeway that it is going to be applicable. Hence the problems that are being experienced by us and the Khoisan leaders. Because until such time we do have a law that is in accordance with the Constitution, we're going to have a problem. And in the Eastern Cape, there are many claims and counterclaims around the Institute of Traditional Leadership. And, those will stabilize if and only if we do have courts. All our issues, you can see there is a labor court in South Africa, there's equality court in South Africa. All other sectors, they do have their specialized courts. We believe that we do have aspects that could be able to develop this law. Among those aspects are you academics. For instance, there are judgments that we do deliver, but those judgments, like the judgment of the praetors, those who understand law, who actually developed the Roman tax legal system, you could comment on those judgments, and with a view that at the end of it, our system of law is recognized. Again, there's the issue of codification. Our law is not codified. So any Tom, Dick, and Harry would come up and then say, well, this is a law. The last point I want to raise is the issue of us lawyers. The reason why many people are against traditional courts to exist, they say we are oppressive to women, and which is not true. I don't have time to argue that. Two, and that we don't accept lawyers. We have been saying on this, who has passed Pondo law, for instance, Zulu law, then Tswana law? The aspects are the Tswanas themselves, are the Zulus themselves, are Xhosas or Pondos themselves. That is why, therefore, our system is not a system of mediation, as some of you are saying. It is based on the principle of reconciliation and nothing else. That is why, therefore, it is necessary that we need you academics to help us. Hence, we're so excited when you invited us here. And as I say, we will continue to be part of you because we believe that in the transformation of the society in South Africa, we are needed as experts who are practicing this on a daily basis. I don't have a court, I can even have a court at 12, I can even have a court at 2, whatever. But those people that can represent, for instance, my mother one time raised an issue. He said, "Oh, I'm not going to open my mouth. I want my son here, who's the crawl head of that family." She raised that point. And again, if any matter comes to a court of law and we in that family, we didn't discuss the issue, we have got a right to say, no, this matter must go back with a view that we can discuss it in our family. Why? Because we want to reconcile the families. There are many, many examples, but I hope if we are going to have questions, I'll be able to expatiate because I'm told my time is up. Thank you very much for giving me this opportunity.
Thank you very much, Nkosi. Interesting, discussion. But the Q&A session is coming. Is coming, yes. Prof. Pierre de Vos, over to you.
So I would like to thank the organizers for inviting me. I'm very honored to be at Forte the first time that I visited. And I came partly because I think it's important to learn from others, and I learned a lot. And was also moved, especially by all the student presenters. I can just imagine how proud your lecturers are of you. It's really inspiring to see young people really engaging with the issues. So I'm a constitutional law professor, and I know that there is a lot of gripes in the room about the Constitution, so I feel a little bit like the owner of a butcher shop having to speak at the vegetarian conference, but I'm going to try and say something that hopefully will be useful to all of you. And I'll start with a poem. The African-American poet Langston Hughes wrote this poem in 1969, maybe, called Tired. I'm so tired of waiting, aren't you, for the world to become good and beautiful and kind. Let us take a knife and cut the world in two and see what worms are eating at the rind. And I'm reading the poem because I think when we want to make a better world, we have to do the difficult things. We have to look in the dark corners, in our own souls, in our own discipline, but also in others, to try and see where the problems are and to try and make it better. So this topic is also not mine, chosen for me, but like a politician, I will just answer the question that I want to answer and not the one that was really asked, and I'll do it in 2 bits. I'll first talk about the South African Constitution and what it says and why traditional leadership institutions formalized is not so easily to be, it's not easily in harmony with the constitutional text, apart from the provisions that has been often mentioned here, section 211 and 212. There are other provisions that create difficulties. Section 1D of the Constitution, which says that the values of the Constitution is the supremacy of the Constitution and the rule of law, because the rule of law assumes that exercises of public power, and if there are formal recognition of traditional leadership in certain ways, they would exercise public power. Such exercises would have to be in accordance with pre-announced rules, laws, and it will have to be rational, We know if you follow the law reports, rationality is one of the most important things that the courts use to nullify the excess of public power. Then, of course, there's also the value of universal adult suffrage, a national common voters' roll, regular elections, and multi-party system of democratic government to ensure accountability, responsiveness, and openness. So it's not democracy, it's a specific type of democracy, voting through political parties in general elections based on a common voters' roll, to the extent that traditional leaders might have influence or say or real power in national politics, that it's not compatible with that provision as it is then expressed in the arrangements of the national, provincial, and local government spheres. But having said that, we have to cut open the world in two and look and see for the worms. I will say, of course, the Constitution is not set in stone. It can be reinterpreted, it can be amended, it can be abolished and replaced with something else. For me, the interesting question is, if we consider this, what is it specifically that we would want to do differently? And I'll start with the assumption which I think is at the heart of this whole project, this conference, is that what we are trying to do is really a response to what some people would call epistemicide. So the killing or the devaluing, the marginalization of an indigenous knowledge system. How are we going to respond to that? What is it that has been lost and that will make our lives and the lives of South Africans better? Will better align the law with how people really live? Because I think there is a real problem in a disalignment between what what Parliament does and the laws they pass and what actually happens. And so I want to make one small, modest proposal, and then I want to talk a little bit about the bigger picture. One modest proposal is that might actually be feasible is a possible amendment of section 39(2) of the Constitution, which says that when section 39(1) of the Constitution, which says that when interpreting the Constitution, courts must promote the values of the Constitution, equality, dignity, freedom, may consider foreign case law, and must consider international law. It doesn't say customary law must be considered. And I'm saying that because I think sometimes bringing the human rights and the customary law closer together could be possible if there was a provision in the Constitution that says, in interpreting the Bill of Rights, how customary law actually is lived, the underlying principles of it, the assumptions about the worldview, that could also influence how the rights are interpreted. For example, recently there's been quite a bit of writing on family homes, the concept of a family home, which is not something that if you're white, you live in the suburbs, you have a house, it belongs to one person, it is registered at the deeds office. It is not a family home that is for the family, which in terms of the law now, it has to belong to a person with a name on it. And what happens is one of the family members' name is put down, that person then passes away, and now the family home, it doesn't belong to that person, but the family home in law belongs to that person, and the courts do not know how to deal with this. So if we had the right to property, if we said that the common law, sometimes I joke and say common law is customary law for white people, if the common law could be influenced by the customary law so that it is not, this is symbolically, customary law is kind of not the indigenous law, it is there on the side. It can influence the customary law, the common law, or the interpretation of legislation, and of course also how the Bill of Rights is influenced. So that's one kind of idea. Much more radical would be a rearrangement of governance in the country in ways that is mirroring or borrowing from traditional leadership. But there are difficulties, and I think when we think about governance, the Constitution, 2 minutes, then we have to understand that the Constitution is there because of the problem of power. It is made not for when things are going well, it is made for when bad people get into positions of authority or bad people have power. The assumption being power corrupts, absolute power corrupts absolutely, and so you have to have mechanisms to limit the abuse. That's why we have elections, but there can be other ways of holding people accountable if you change it, but it needs to be real, it needs to be effective. The system of checks and balances, the idea that if all the power is in one group, and this will be a real challenge if we try and think about traditional leadership, there needs to be checks and balances. The principle is because if there's not, if rogue elements, if we want to call them that, gain the power, it will be very difficult to check them. There are many examples in the law reports of this happening in traditional communities, especially in where mineral rights come into play, and big corporations, another body that uses and abuses power, they get the ear of traditional leader, and the traditional leader give them the right to prospect on the land or to make a mine to the detriment of the community. There are several cases like this in which the court then sided with the community against the traditional leader. That is a kind of check, but it's not the only check. Lastly, we have the difficulty of courts. And I heard the traditional courts here being discussed. What nobody has said, and that I wonder now how to deal with this, is that section 165(2) of the Constitution says that courts are independent. All courts, you can only be a court if you're independent. So if you think independence, you can think about what independence is from a very Eurocentric perspective. But I think we should start, and this is just one example, start doing the work of thinking, what can independence mean? How can it be secured in other ways than in the ways that are now at the moment written into the Constitution? Is it possible? Maybe it's not. Maybe it can be. And so I think, to conclude, sorry I've taken 1 minute extra, is I want to challenge everybody to think, what is it that we can get from customary law, from the institutions? What work would it do for us in bringing the law closer to how people actually live? But at the same time ensuring, because power can corrupt anybody, ensuring that the system has safeguards and checks and balances in it, so that the kind of authoritarianism that we see there in the orange one, Donald Trump's America, cannot take hold. Thank you very much.
Thank you, Prof. Interesting panel. Constitutional law expert, customary law, indigenous knowledge systems, and right at the heart of the traditional Congress. On a lighter note, Prof. De Vos, I remember sometime in 2009, we were at the Constitutional Court as researchers. So we had looked at the judgment which cited a certain constitutional provision, and that judgment was delivered. The following day, first morning, there is an article, the Constitutional Court relied on an incorrect provision. And we were sitting there, 24 law clerks, having proofread that judgment. And Professor Pierre De Vos was correct. And the court had to withdraw that judgment and, correct it. But leaving that aside, Prof, let me invite Professor Nwauche on the podium. Thank you.
Because very much often within customary law relates to family matters, succession, chieftaincy, and all that. But I'm talking about indigenous public law, ideas about how our traditional communities are governed and how that should influence or will influence what happens in the bigger society. So this was what I had put together as a title after this judgment about a compulsory traditional levy in Limpopo, and the Constitutional Court struck it down, and rightly so, because the manner in which the Limpopo Act crafted the requirement of the premier for a compulsory levy. There was no distinction between members of the community and those who were living in the community, and there were sanctions. So the Constitutional Court was correct in the fact that it looked like a tax, and taxing powers constitutionally belong to different parts of the South African government and not traditional rulers. But this is the real meat of what comes from that judgment, because what's important in that judgment is not to affirm that the Constitutional Court was correct, but the leeway it gave that you could have voluntary levies. And if you have voluntary levies that are based on consultation, consent, participation of members of the community, and accountability, then you're talking about ideas about indigenous democratization. In other words, is it possible that you raise money in communities, which all communities continue to do, because that's how they survive, and still tie it up with prospects of democratization, which will include accountability, right? That communities raise money and that it is spent in an accountable way. So that is the implication of that judgment. Communities can collect voluntary levies, but it has to be imposed with the participation and consent of members of the community. It has to be spent with their oversight, and there has to be accountability. And again, as a side, if you like, remark, we always like to be in binary positions and in describing the social processes that we have in South Africa. Traditional rulers are bad. Traditional communities are hierarchical, they are patriarchal. There are different traditional communities in South Africa and in different places. Some are good, some traditional rulers are good, and some traditional rulers are bad. But when we lump everybody together, we confuse what is essentially a social process that is not homogeneous, that the whole idea about different segments of a community working. And indigenous philosophy, indigenous democratization principles show that our communities are democratic. Communities across the world where you have regents and kings and co, and yet different parts of that government have elected parts. That is the reason why I said one would leave us with a thought process. What does indigenous democracy really mean? Is there any community where there are no social forces that are pushing against each other in fighting for recognition, in fighting for accountability from the chiefs, in fighting for representation? Which community in this country or Africa in which an Nkosi takes a decision alone without the participation of either chiefs or members of the community? There's none like that. Because that's why we're a social community. People push their interests. And that's what democracy is all about. It's like deliberation, it's like contestation, it's by persuasion. And that's the basis of what I put out together, which is that if our traditional communities are to survive, and I call them the fourth informal level of governance in South Africa, I'd like you to think about how gradually across South Africa, self-help by different communities has become a way of governance. There are neighborhoods that take care of all their social services and facilities through self-help. This is something that has happened in other parts of Africa where social services are provided by communities themselves. I went to a neighborhood to pick up, join a friend of mine in Professor Diala in Belleville, and they had a security patrol which was paid for by the members of the community. There is an informal level of governance in South Africa now. There is no province where people are not contributing to help themselves. Our traditional communities are in that light, should be encouraged to be in that light, to provide services which the state is unable to provide. Can they levy for the provision of those services? That's what the courts are saying. It has to be voluntary. But if you levy, you have to account for it. If you levy, you must consult those who are your subjects. If you levy, we need to think about those who are foreigners who are living within your jurisdiction. If you levy, you need to think about the sanctions that you impose. Can you refuse to give a letter of introduction because somebody is not paid a levy? Which is one of the reasons why the Limpopo Act was struck down, because there were evidence that members of the community who had not paid levies were denied letters of introduction, which is crucial for entitlement to state grants and all that. So these ideas about how our systems are not too strange. Our communities are communities of deliberation and contestation. There are different groups. The women and the youth are fighting, are struggling, are persuading each other about the ideas, are trying to reach a consensus of what happens. That's the reality in our communities. And the reason why the levies are important is that we need to think about how these communities become more resourced. This idea of three systems of government, these ideas and flashes of service delivery across South Africa, it's due to the fact that many levels of government in South Africa don't work. The municipalities, many of them, don't work. And so we toy, of course, we protest on service delivery. But yet we have a system where some provision of facilities, some provision of services can work. And we live in very perilous times in which mass unemployment is knocking on our doors because of artificial intelligence. Ask yourself how many jobs have been lost in South Africa in the past 9 months. In the Eastern Cape here in Port Elizabeth, I've counted, officially reported, close to 50,000. It's like human rights. You have to fight, you have to contest, 3 steps forward, 5 steps backwards, and all that. So, again, the last thought. We are leaving the conference with all kinds of binary ideas. Culture is good, culture is bad, spirituality is, the constitution is wrong, the constitution is right. Binary hard positions do not represent the social processes that underline norm-making, our constitutions and code. There's always something in between, and that's why, you know, as I said at the dinner speech yesterday, we need to do a lot more to think about what our rules are and continue the debate, because there's not enough. Anybody who's listening to this conference will see that there's a lot more that is possible, a vastly lot more. How many groups are in South Africa? How many subgroups are in South Africa? What is the level of our customary law? It's easy to stay here and think about the Xhosa customary law, right? Well, and if you look at the history of the Xhosas and the migration with the Zulus and the wars, you ask yourself, what is South Africa made of? Rich, diverse, but one in which you need to be careful of, if you like, mapping as a first step before, you know, we get into thinking about what these laws mean. So thank you very much.
Thank you, Professor Nwauche. I think the students will have so many topics to write on. I don't foresee us running short of topics as of now. Ladies and gentlemen, we are getting to that moment you have been waiting for. There is nothing wrong with customary law, provided that it is based on the consent of the people, if I follow Professor Nwauche's argument. Professor Pierre Defos, if I follow you, let us try to harmonize the two systems. What can possibly work here and there, and then we build from there. Nkosi Nonkonyane, during my student days, you know, I used to enjoy that part where a man can take more than one woman. But later on, when the Customary Marriages Act came into effect, then it settled the debate. I could not argue anything. The floor is open for questions. This time, can I please start on the left? The first hand, one at the back, and you'll be the third, sir. Yes, you may start. Please indicate to whom you are directing your question to. Straight to the question, no background and so on.
Thank you very much, Program Director. Allow me to reintroduce myself. I'm Vuyisa Pikashe. I'm currently a second-year student at the University of Fort Hare. Just because the Program Director said we must not go to the background, so I don't feel like my question would cross the way that I wanted, but I would just be brief. I couldn't keep quiet while Professor was talking about the Constitution, because I love reading Constitution a lot. So it was like more of provoking me to actually raise these questions that I always had with the Constitution. Professor, you've made mention of the founding provision, specifically subsection D, which I want to again re-emphasize on what that section states, section 1 of the Constitution, which the South Africa is founded upon. It states that South Africa is one sovereign state found on the following values: human dignity, achievement of equality and advancement of freedom and right, non-sexism and non-racialism, the rule of law and the supremacy of the Constitution, and adult suffrage and multi-party system. So what I want to understand, Professor, is that in as much as I was hearing to the presenters, even from the day that we have started, none of the speakers have actually went into context of the provision we have, Section 74 of the Constitution, which requires the amendment of the Constitution. So the question that I have is that we want the customary law to be codified. My question is that how do we codify it, or do we just subordinate the codification of the African customary law, or how do we go about trying to fit in within the Constitution, and noting that the Constitution is entrenched and the process is rigid in which how the Constitution can be amended. So I want to ask to you, Professor, that how do we go about the process of including the customary law within the Constitution, knowing that the Constitution is supreme, or do we just look at just only subordinating the African customary law within a legislation? Thank you very much.
The second question at the back. When I walk closer to you, you must know that you are doing a background.
Concha, die Kaikop, Danakop, Tikwa, Usasip Group, the Karamakais, the Korakona. I've got a question for my leader there in front, Nkosi Ngonyana. As a senior traditional leader and my provincial chairperson of Controlesa, would you agree to the idea of formulating a regulatory framework or regulations on the practices of circumcision, which possibly will see the end of deaths we see each year in this practice? This framework can also encapsulate punitive measures for malpractices in codified form that can be criminalized. If not, why not? Of course.
Thank you. Thank you. Yes, sir. This is the gentleman on your left. You've just passed. Yes.
Thank you, Chair. My question is directed at Professor Pierre de Vos, and it speaks to Chapter 2, Section 9 of the Constitution renders me equal to anyone. A bone of contention that continuously came up with many controversial views, of course. Does this notion of equality, in your opinion, as an individual and an expert on constitutionalism, include equal access to land? And if yes, knowing that land was dished out freely by the British Crown, which gave land to the white minority, do you agree to the expropriation of state-owned land to the black majority in the same way it was dished out during colonialism and apartheid by laws such as the Grey Act of 1894, the Native Land Act of 1913, the Native Trust and Land Act of 1936, and then the apartheid legislation starting with the Group Areas Act, and they are too many to count. Do you agree that a process of restoration of land would speak to equality if we do this in an African context where land is restored to create that balance? Thank you.
Thank you. Panelists, over to you. You may respond.
Thank you for the questions. Yes, so the bad news or the good news, depending where you're coming from, is that the Constitution does make customary law and traditional leadership subject to the rest of the Constitution. So during the negotiations not at CODESA, but in the Constitutional Assembly, those clauses in section 211 and 12 were quite contentious. There was a conglomerate of women's groups who fought very hard that customary law should be made subject to the rest. A recognition of customary law should be made subject to the Constitution. And in my view, they won The clauses makes it clear. It is subject. It is, we can change it, but that is the position. But one can actually, of course, the Constitution is not self-executing, it is not self-evident. The provisions are often phrased in rather open-ended terms. Everybody has their dignity respected and protected. What does that mean? The court said it means you have a right to family life. It's not written in there. They made this up based on other judgments and so on. And so the courts, those provisions and a more positive appreciation of the knowledge system that in which customary law is embedded by judges could change at least some of the ways in which the constitutional provisions are interpreted without amending it. Of course, it can also be amended, but Section 1 would require 75% majority, so that's never, well, it's not going to happen very easily. On Section 9, I don't think Section 9 guarantees equal land ownership for everyone. That's not how equality works, because it's quite a little bit more different. It's different from equal benefit for everyone. That's not how the courts interpret it. It is not being unfairly discriminated against based on one of the grounds, and being treated equally before the law. But, of course, land dispossession is the original sin from which South Africa and the Republic that it is now called was born, and land restitution, redistribution, whatever you want to call it, is imperative. At the moment, it is not possible to do it in the way that you say, because the provision in the Constitution on property rights require land restitution and redistribution, but with the payment of compensation that must be just and equitable. Of course, if you were elected as a judge of the Constitutional Court, you would be able to interpret what was just and equitable in the way that you have now suggested. Whether it will be plausible, I don't think so, but it is possible. But that there should be, and that there hasn't been enough land redistribution is an absolute fact. It's a scandal, in fact. The fact that so much of the land redistribution has been marred by corruption is also a scandal, but it doesn't excuse the fact that it hasn't.
Thank you for the question on circumcision. I may indicate that as traditional and Khoisan leaders, we don't promote circumcision. I can see you are all shocked. We are promoting initiation of boys to manhood. It's quite clear that we must just be very clear on terms. And initiation of girls to womanhood. That's where you find us in. When this matter cropped up, of course we had a problem of death initiation. We must own up. When did it start? Many people may not know. It starts during the Sianyova campaign, when there was defiance, and defiance of any authority, including the authority of traditional leaders. We then, fortunately at that time, I was chairing the House of Traditional Leaders in 1996. We then established our own commission under Nkosi Holomisa. Went around the province, found the mischief behind that. But one critical finding is that Casto can never beget any injury, let alone death. But it must be administered by the person or persons who, in terms of the custom, are empowered to do. And the critical finding was that traditional leaders themselves. But at that time, there were no powers. Go to the Constitution. There are no powers who have got a role and function, who are indunas in this country. Yet, do have power in terms of customary law. That's what we are maintaining. Therefore, when there was this issue of an act that must be passed to regulate, we indicated that unless and until the Constitution is amended, it will beget problems. Yes, it did, because the Eastern Cape government passed the legislation, again in terms of the legislation to be in accordance with the Constitution. It had to say, MEC for Health, whether initiated or not, will administer this. Death continued. And in 2016, there was an act that then said, no, the House of Traditional Leaders will come, will lead, but with the support of department, which we welcomed, of course. But there was a decline. That was clearly indication that if this is then taken to where it should be administered, there will be no death, there will be no injury at all. Of course, the government reversed. The national legislation was passed, say now is the Premier, the New York, and everyone else. We are role players. The death continues. The point I'm trying to say, yes, you can regulate, but you must regulate in terms of the custom. If you don't recognize it, I'm telling you, as I speak now, I can't say this, we passed winter season, there were deaths. We're going for summer season. Your guess is as good as mine. But when we did this, I was in Kofimvaba, Nkosum Goldwa. 30 initiations were administered. They all went there. We were there. Launched by traditional hands-on with powers in terms of their custom. All went there alive and came back alive. That is the thing that I think South Africa must dawn in our mind, that yes, you can have a constitution, as Professor is saying, but that constitution has no royal seal of approval. That is why we do have a junk state in South Africa. If there will be election next year, 30 of you go to election and go and vote, and 100 don't go. In terms of the system, that government is going to be recognized, but in terms of legitimacy of the people, it will be questionable. That is why, therefore, I'm saying, thank you for raising that, but I think we need, therefore, to think deeper, deeper and deeper with a view then to address this question. The elephant in the room is the westernized constitution. That is the really elephant in the room.
Thank you, Nkosi. I think the timekeeper was caught in between. How do I stop Nkosi now? He decided to disappear. But now there appears, to be two schools of thought from the discussions that we have had. In about 5 seconds, I want us to wrap this panel discussion. Obviously, discussions will go on the tour and so on. Professor Nwauche, I will start with you, just in 10 seconds. What is the way forward?
In terms of our traditional communities, I think that there should be more democratization, more involvement of people in governance. The idea that royal fathers have the final say in communities doesn't work and has not helped Africa. The traditional communities can survive with more participation by members of the communities. Once you have that, including women, I have a radical view about the equality of women. I think that women can be equal members of traditional communities and our societies will survive. But that's a matter for a different time. Thank you.
Thank you, Prof.
I would say that my message would be that there's an urgent need, not for talking about customary law, its position, for the substance, to think, okay, this indigenous knowledge system, what does it give us? How to understand it? How can we get it to understand the law, if we're in the legal discipline, in different ways, in ways that reflect indigenous ways of being in the world? That's substantive stuff. If that happens, it will be much easier to convince also the courts and the people sitting there in that beautiful building in Braamfontein to take it to heart.
Of course.
Thank you so much. Let's disabuse our mind of this hatred against the African legal system and African norms and values, and give a space to the people with indigenous knowledge system so that there could be that principle of equality. For instance, I heard that there's a criticism that we cannot preside. There will be no independent judiciary if we continue to preside. That is not true. That notion is based on ignorance, in fact. Because if there's a court here, I will preside as a traditional leader, senior traditional leader here. You will decide, we will discuss this matter. And I will not let that matter be settled unless there's consensus here. Not sufficient consensus. If then there is a problem, we'll come next week so that we persuade each other. That is why, therefore, I'm saying, let us abuse our mind and let's give us a space. Fortunately, we do have experts. We can come to the university and just give talk. That is why I decided to come and give talk without writing. Because I'll talk smart so that I can look good to you. But if I speak my mind, and then you will really get the gist of what I'm trying to say. Thank you.
Thank you, Nkosi. To our panelists, thank you. A round of applause for them. And a round of applause for you, the audience. Thank you. Before I call on the last person to finalize, I'm instructed to update you that please take care of this booklet. It will be very useful during the tour. That will be conducted by Mr. Ladokun, who is here with us. If you could please stand up, sir, so they can see you, who will share a very rich history about our institutions. Without further ado, please allow me to call upon Judge Madondo for closing remarks and vote of thanks. A round of applause for the judge.
Thank you. I'm given a difficult mandate to perform, but anyway, we've come to the end of this conference. A number of things came out during the presentations and during the questioning and the comments. But what is remarkable is that people are not happy with the Constitution, which is a big problem. So there are sections in the Constitution dealing with traditional leaders, culture, and all those things. There's section 211, 212, 30, 31, and 15. I think that will help. Maybe the committee will take this work further to look at those against the practices of traditional people. There also a debate about whether one should consolidate or modify, codify, or unify. So people not at the moment, they're not clear in their minds what they want to do. There are some people who say, no, traditional communities follow disparate laws, but what I can assure you, law matters may seem to be disparate, but largely are the same. Throughout South Africa, even Africa, they're just the same, just minor difference. So the people who are mandated to work on that, they can easily do that. It's not a problem, because you can use one as a case study and you look how others practice those laws. And then you find the common understanding and the common thing all these people are doing. Then you work around that and see what can be done about it. Because there are problems. People say, this law is not written. It's just understood. But even the common law well is written by authors and others, but also it developed through decided cases. And so our customer law also now developed according to that. So we look at how the court interprets this and how does that affect the people, because there's an outcry that when these acts, when these customs are interpreted, they are not interpreted in the way the African people understand them, or in the way that will benefit them. So it means that some other people, they take a center of the head of those people who are interpreting this, and interpret them in accordance with the common law, or substitute this with common law, which causes a problem. Because once you apply customer law, you must apply customer law throughout. But if there's a problem, then you want to find the solution, you may find the solution from customer law, but that should be clearly spelled out, as well as the people dealing with common law, they can also find solutions from the customer law, as vice versa. It's not only a one-sided story. But some say, that's just like that gentleman, that young man, a young attorney or a young advocate was delivering a good making a good presentation here. Pigashi. It says not apply in its full context. So once we've finalized all these things, we know, everybody will know what the full context of the customer law. As I've indicated earlier on, then we talk about codification. I have a fear with codification because if it's going to be codified, but it must be codified in a way that it leaves a space for development. Because that's why our customer law did not develop to meet the changes, the pattern of changes of life. Because this was codified, it means it's stagnant. It doesn't grow with time. So if we're going to follow the same thing, that will be a problem. And you look at unification, the unification with customer law, I think that will help the customer law also to, also to influence the common law, because there's the unification. You look at ownership of property. The common law approaches an ownership of property in a different way. What they look at whether that right is registered. If not registered, well, woe unto you. But on the African side, the right need not be registered, but there are things which should be done. That when a land is assigned or allocated to somebody, the one in authority calls the people who are residing there, and they also agree that this person should be located this side, and you identify him from this point to that point, from that point to that point, this is your land. That land will be respected for generations. In African setup, we don't need the registration. So if those things can be reconciled, but fortunately talking to the people in Parliament, because those are the people who can help as well, so to be able to make a progress in this thing. Because courts operate on something before them or interpret what is before them, but there are instances where the courts cannot go further, where we need the Parliament to legislate on that. The other thing, our customary law is rich, because you see, that word Ubuntu, all the people are going around talking about Ubuntu. Where Ubuntu is found? Ubuntu is found in Africa. Well, we are sort of collective people rather than individualistic. So in that way, we are able to help one another. We are able to, if one feels a pinch, everybody feels that. So also the compensation, section, if I'm not mistaken, section 301 of the criminal procedure provides for compensation for the victim. That has never been the case. Those have been stolen from the customary law, and there are many others I can identify if I'm giving that time, but this is a matter for another day. Okay, well, you talk also about the Traditional Court Act. I think the committee will be assigned the duty to take this part must look also at that act and see what does it provide, and look at the customary practices and customs, what the people expect, and see how to marry those things, because that act, it paves the way for these customs, for these practices to be implemented. So it retains that dignity of Ngozi Nongonyana and others to resolve the dispute or cyclic dispute between their subjects before anything happens. Because if this structure does not exist, there will be a problem. More particularly in traditional communities. Because on a day-to-day basis, Indunas, Makosi, everybody who sees to it that disputes are resolved and people live peacefully, there's a reconciliation and all those, and respect and all those things. You cannot maintain that through this common law or legislation, because jails are full, despite these laws. But when these jails were not yet in existence, we managed to control everything in our areas through customary law. We resolve a number of disputes. Coming from Singa, where there have been faction fights, there were police, there were everybody, but even the courts, they approached the faction fight in a different way, as a very less serious offense, which carried a light sentence. But how did we resolve this thing? We resolved it through customary ways. The last faction fight took place in 1999. Let's do a last one. But if you look at it, they started in 1895. Colonial government, apartheid regime allowed these things to go unkept. Yes, the other thing we have noticed, the application of equality clause, the section 9 of the Constitution. People and courts seem to equate everything, even this is not equal. Because they have to determine the purpose behind the whole thing. But you see that, well, this is a female, this is a male, a boy child and a girl child. So a boy child is entitled to succeed to chieftaincy or kingship. Why the girl child is not? So the reason for that is to have continuity in the bloodline. It's not a matter of equality and so on. Even in the family head, not everybody can be a family head. A family head, a person who takes the place of a family head is a person who identified by our customs, not by the Constitution. So I don't think the Constitution is there to create customs and practices for African people. but is to regulate and make it more appreciated, rather than stifling them. So, there's a big problem. People have to look at this equality clause and the way courts are interpreting it. Because the problem started in this case of Shuluban and Namita. That's where the court went wrong. Because I would say it went wrong because it realized that it made a mistake by allowing what the council was saying. Because in the midstream, they said no, neither the sons nor the daughters of this lady will succeed. That on itself causes a problem, which indicates that it's against the custom. And lastly, what has been touched upon is the independence and impartiality of traditional courts. Professor DeForce, there's a difference when it comes to that, how that is being assessed traditionally. Because this traditional leader, they don't preside as magistrates or as judges do in their courts. But the people presiding there are the people sitting or attending that. The traditional leader will only pronounce what the people have come to. So everybody in attendance is the right to participate, to put questions. There are people who have become prosecutors, there are others become magistrates, there are others become witnesses and all those things. And in our culture, the witnesses can sit there, but that doesn't cause problem to the proceedings. Because when even he has been sitting there, but when it's being questions, then sitting there would not impact negatively. But in the European style, on the common law style, a witness must stay distance away and come out and take some oath and lie to the teeth. You see? So the impartiality of those things, it depends that it's not the only one person deciding, but the whole community attending the court proceedings, they participate. So, and also we don't have that distinction, a legislature, a judiciary, and executive. We don't have that. And all these things are linked to the Ngosi or the king. But the king or Ngosi is not acting alone, is acting in council. So there's a marked difference, because if you approach it in a European style or in the common law style, you may go astray. Because that's why we must have a proper understanding of how these things are done. At one stage, when I was interviewed for appointment, Bezos was telling me that, no, these courts are this, are this, are that. I said, have you attended these courts? No. So, Professor so-and-so, who talk about people who have never been attended, who don't know, just talking on theory. I was born and bred under these things. I know them. there's no more fair and impartial court like the traditional court. I can stand for that. Even in the face of a person shooting me or threatening me, that is the most fair court I have ever seen in this world. Now, those are the remarks I have been asked to make. If I miss some people also who have been in this court, it's not a court. We've been in this hall, we remember them. But this is the last day of the conference. So all what we have said will be taken into account by a committee, will be mandated to consolidate all these things and document it so that you people will see it now in a document. Then next year, most probably in July, we'll convene again. Now you have your documents. So if we agree, we'll just have a way for it. We'll carve a way for it that now we have these things. Fortunately, we have people from this legislature, people from the executive, we have people from the traditional authority, traditional leadership. We have people who were in the Roman time called the proletariat. So everybody is here. Everybody has participated. But then we look at that and see how should we take this thing further. But people stop lamenting about you being taking your land, some people taking your land and so on, because that thing drags you back. Yes, the land has been taken, then what to do to recover that land? We are looking at the ways now. How should we make our customer law, or should we make its presence felt in South Africa, in Africa, and throughout the world? As Professor Shane there was talking here, I was looking at how it can help the restorative justice, the number of things which can be borrowed from our system to help resolve disputes, because our system is rich in that. They can be borrowed. Even in treaties and wherever, you can look at that. Because if a person makes a treaty with South Africa, these rules and principles, if it's going to affect the adherence to customary law also should be there, should prevail. That thing should be done according to customary law. As you, Kosinongonyane, you have somebody residing in your land. At the time of the promulgation of or negotiations of traditional courts, there was a clause which was saying, no, when you are residing there, you can elect if Nkosi summons you to the court, whether you go or not go. I ask, which court is that? Because this court should be accorded the same dignity as courts. And if we are summoned to the magistrate, can you sit down and say, I'm not going there? You go there. But if you have an objection to the jurisdiction, then you raise it in a proper way. But that was a way of demeaning the traditional courts. And say some people, some more, what is this organization, said, no, these people are inherently discriminatory. They're oppressing women. In the first place, we must ask, what is the procedure in these things? And when did women start attending these proceedings? When they're in attendance, they're in fact being discriminated or not just assume. People are just working on assumption, and some writing papers and so on. When you ask that person, cannot answer. Well, I think maybe I've talking too much, but nobody is prepared to stop me. That's why. So it means, that means what I'm saying is still relevant because nobody's jump up and said, oh, stop now, this is enough. Okay, thank you, Professor Johnson and Professor Makanya and all others who in control of this university for inviting me, but you must know that now I'm done. So to keep me for a week here is an offense. Thank you.
Thank you, Judge. Colleagues, it's time for the tour, but please, after the tour, come back here so that you can enjoy the last final lunch. I'm told that the things are looking good up there, but after the tour, thank you.
It takes